Let's get back to some of the core sort of philosophical critiques of the ruling itself, because, there's the practical aspect of there's been a bit of a mess in the lower courts on how to apply Bruen. And, you can certainly, there's probably a lot of things that go into that, whether it's genuine misunderstandings between courts who are acting in good faith, or I'm sure there are gun rights advocates who would accuse certain lower court judges of just, again, the old critique of the two-step test, whether it's that it was meant to kind of ignore what Heller was saying and get around it. And so I think you had that same critique from gun rights advocates on some of these lower court rulings that uphold laws by applying Bruen in a way that they wouldn't agree with. But going back to the larger conceptual argument, one of the things that you brought up this idea of it's a harder test to do this historical analysis than it is to do, a balancing test that balances government interests against the, rights of people. And, one of the critiques of that I've seen in the gun rights space is, for instance, from somebody like Mark Smith, who has argued that, it should be easier for judges to look at something they understand, which is the law, historical statutes, and be able to interpret what those, the how and why of those statutes and whether they are close analogs to a modern statute than doing like social science, balancing based off of whether or not this policy has the right effect. You understand, like the critique is basically judges are actually more suited to do this sort of test than they are to do, a test of whether or not a certain gun policy has the right percentage effect to justify, the balancing it against the rights that are implicated.
Yeah. And I think that's certainly the perspective that Bruen raises in the case itself, where it says, we think this is more administrable than weighing costs and benefits. Right. And one of the ways I think it says that is it talks about these default rules and presumptions, including the notion of party presentation, that the courts aren't supposed to be out there roving through archives and doing their own historical research, that the government's burden is to introduce the evidence. And so I think that's, I think that's the presumption that Bruen was going off of as well. My view is that, we talked about First Amendment jurisprudence a little bit. Means in scrutiny, intermediate and strict scrutiny is a fundamental feature of current First Amendment law. So this is what courts are doing all over the place when they deal with a First Amendment question. Almost all of the time, if they're not saying that it's categorically unprotected speech, things that have been unprotected forever, like true threats, then they're moving to means in scrutiny, and they're asking questions about what's the government's interest and is this law narrowly tailored to serve the government's interest. So kind of on the other side, which is the notion that whatever may have been the case in like a general understanding of what a judge does, at least for the past since the 1960s or so, courts have been applying means in scrutiny. They've been doing strict and intermediate scrutiny. And so it's a task that courts are familiar with. And I just want to say, one of the few courts that adopted the two-part framework initially were conservative judges who were trying to faithfully apply Heller. So, I think at least the two-part framework did not arise as a result of judges who wanted to get around Heller. So Judge Diane Sykes on the Seventh Circuit, Judge Anthony Sirica on the Third Circuit, two very early circuit court opinions that they authored where they adopted this two-part framework. And they're conservative judges appointed by Republican presidents. And, my read of those cases is that they thought this was faithful to Heller. It turns out Bruen says that's not the best reading of Heller, but I don't think it was the two-part framework was designed in order to get around Heller. I think it was designed for judges to say, look, we do this in the First Amendment context, and we know the First Amendment is an individual right that's a fundamental individual right that has strong protection in the courts. And so we think this kind of test is the same thing we should do in Second Amendment spaces. But yeah, I think you're right that there's this debate over which one of these kind of two tasks is harder, doing the historical inquiry or looking at historical statutes, or doing this kind of means in scrutiny where you're analyzing the policy effects of a given law. I think both those tasks are hard. And yes, we could certainly disagree over which of those tasks is harder.
Yeah, fair point. And I think maybe it might be a part of a larger effort by the current court to push back on balancing tests generally.
Yes,
That
I
seems
think
to
that's
be
right.
the implication in Bruen, at least, from Thomas's opinion. So that
Right.
it
Yeah.
might be part of a larger
The
project.
critique of the in Bruen is not limited to Second Amendment cases. It's more like we don't do this for constitutional rights generally, which might mean that it's going to do that for other areas.
Yeah, and obviously the other critique of the two parts, I think one of the main critiques was that a lot of judges weren't really applying intermediate scrutiny. They were applying more of a rational basis.
That intermediate scrutiny applied in too many situations, and that courts were applying it too leniently. Yeah.
Right. But either way, the other critique that I hear a lot of about some of these complaints with Bruen deals with the analogy process, right? I mean, obviously, there's going to be some there's wiggle room in that process because, like you pointed out, like what exactly is an acceptable analogy? I think the court in Bruen it seems to be implying that if there's any question, you should go towards the interpretation that is more what's the right word here? More that gives the Second Amendment rights more leeway, I guess would be there. That's how they seem to approach it. But obviously there's an open question of what is a similar analogy to a modern law from how do the how and why are supposed to match up,
right?
But how closely, and that's why you've seen, a range of answers to that question so far. But the idea that, if they didn't speak on it at the time, that implies that it wasn't constitutional to enact that sort of restriction, this issue that you raised earlier. I think the critique of that is just that there weren't a lot of gun laws at the founding. There weren't a lot of gun restrictions. And most of the backlash to Bruen is just people who wish there had been more and don't like the fact that what that implies in how this standard is supposed to be applied.
Yeah.
Is that
I don't see that as a critique, though. I mean, maybe there weren't a lot of gun laws, but maybe that's because there weren't a lot of gun violence problems at the founding, right? And so it doesn't necessarily shed light on the question that originalists should be asking is, if they confronted the same problems, what did they think the tools they could have used were, right? And so if they had problems of frequent mass shootings or widespread community violence in urban centers, then what did they think the Second Amendment would have allowed legislatures to do, right? That should be the originalist question.
And you don't see the analogy that because, like you mentioned, there is sort of a mechanism for this in Bruen where they admit that, there's been technological advancements, there's new societal issues that have come out of that. And so in those cases, you can use a little bit broader view of what's analogous.
You can use a little bit
but you
broader.
don't think that addresses this
issue.
Well,
I don't think it addresses it because you can use, all it does is say, if you have an old law, then you can kind of you can apply the analogousness restriction a little bit looser, right? So you can find one that's not exactly the same, but it's similar, but maybe not as similar as you'd be required to find if it was the same problem, like, say, felon firearm violence, right? Which the court seems to suggest is the same. If there was just no legislation at all, because it wasn't a problem at the founding era, then the loosening of the restriction with analogousness doesn't really help because there just were no laws, right? And so I don't think it's a complete answer. Sure, it certainly helps when you're talking about if we have a set of laws that we're looking at, how closely are we going to require those to mirror the laws in contemporary times, then I think it does make sense what the court says, which is if there are huge changes in the issue that's being dealt with today, then we should relax the restriction on analogies a little bit. But that doesn't fully answer the concern because it doesn't tell us what to do where there were no laws, even if we had good evidence that they thought that they could legislate on it if there was a problem. Even if we have, tons of evidence, lots of legislators saying, lots of letters between founding generation individuals saying, we could do this, but we don't see the need to do it. Even if we had that kind of evidence, Bruen seems to me to say that doesn't make a difference unless you have an enacted law on the topic. That's the only thing that we're looking for.